Good morning to everybody. Miss Wiesenthal, are you ready to go?
Yes, I am. Sorry.
That's okay. And Miss Federico, I'm assuming you're ready to go.
Yes, I'm ready.
Okay, we are back on the record in the Colorado Public Utilities Commission's proceeding number 24R-0078 GPS. My name is Connor Farley. I am the administrative law judge assigned to this proceeding, and it is approximately 11:30 a.m. on June 24th, 2024. This remote public comment hearing was orally scheduled at the conclusion of the last remote public comment hearing on April 15th, 2024. The scheduling was then memorialized in decision number R24-0351-I that issued on May 28th, 2024. This remote public comment hearing was scheduled to allow, once again, members of the public to provide comments regarding the proposed amended rules. And I want to welcome each and every one of you for being here today and providing your feedback to the commission regarding the proposed amended rules. And let me just say at the outset that if at any time during this remote public comment hearing I mispronounce a name or refer to someone by an incorrect gender pronoun, I apologize and mean no disrespect. Please simply correct me and I will endeavor to get it right from then on out. So let me just cover briefly the public comment process. I covered this last time, but it's always important to repeat it. Let me just say that for members of the public, you can provide written or oral comments regarding the proposed amended rules. Both oral and written comments will be given the same weight. The Commission does not give any greater weight to oral or written comments. However, we've noted over the years that written comments tend to be better, frankly, because many of us are clearer and more persuasive in our written communications than in our oral communications. But you can provide either oral or written comments for this proceeding. So if you, but if you would prefer to provide written comments, there are 4 ways to submit them. One is by email sent to the following email address: Dora_PUC_website at state.co.us. You can also provide written comments through the Commission's website. The website address is puc.colorado.gov. Once you hit the landing page, you scroll down until you see the box labeled file a comment or complaint. You click on that, and that will take you to a form that you need to fill out. And in the course of filling out the form, you'll be asked to either click on or write in the proceeding number for this proceeding, and that is 24R-0078 GPS, as I stated at the outset. Yet another way that you can provide written comments is through the U.S. mail sent to the Commission at 1560 Broadway, Suite 250 in Denver, Colorado, 80202. And finally, you can also provide oral comments that will be transcribed into written comments. And to do so, you would need to call 303-869-3490 to leave your oral comment that will be transcribed, and they can be left in either English or Spanish language. We can just transcribe both. With all of these options, as I've already stated, it's very important to include in your comments this proceeding number so that our administrative folks can put your comments in the correct proceeding. And again, the proceeding number for this proceeding is 24R-0078 GPS. So let me just provide a few instructions for providing oral comments here today. Um, uh, First of all, if you can change your Zoom name to your first and last name, that would be helpful. I can then more easily call upon you. You can use the raise hand feature in Zoom to signal when you wish to speak. To do so, you click on the reactions button down at the bottom of the Zoom window. And then you raise your hand. There's a button to raise your hand that you'll have to click on. If you no longer wish to speak, if somebody, for example, has said everything you wanted to say, please lower your hand by going through the same process. Please try to remain on mute with your camera turned off until your name is called, until I call your name. If you do not know how to use the raise hand feature, just can't figure it out, you may always instead turn on your camera to signal that you wish to speak. To those participating, it looks like we have at least one who are participating in this hearing by phone. You will need to dial *9 to use the raise hand Zoom feature. Please listen carefully. For your area code and the last 3 digits of your phone number to be called by me. When I call those numbers, you will need to dial *6 to unmute yourself. When I do call on you, please unmute yourself and turn on your video to the extent you can. And then begin your comments by stating your first and last name so that we can get an accurate record here. Now, just a few tips on actually presenting your oral comments. When you speak, please remember that we have a court reporter here today who's transcribing everything that's said while we're on the record. So for the benefit of the court reporter, please try to speak slowly and clearly. I may have to interrupt and ask you to repeat yourself or slow down to the extent you do not speak slowly and or clearly. Please try to avoid speaking over top of each other because that makes it very difficult for a court reporter to get an accurate transcript. So I think that's basically it. In terms of my instructions and advice for how to participate effectively in this remote public comment hearing. So my plan here today is a fairly limited one. As you all know, I think I issued an interim decision with further changes, proposed changes to the rules, and gave all of you the opportunity to file both initial and responsive written comments regarding my further proposed changes to the rules. Many of you took up that opportunity and submitted further comments. So I think the record is fairly well rounded out, both from the previous round of written comments and the previous remote public comment hearing, supplemented by my further proposed amendments and then further written comments from you all. But that being said, I want to give everybody the opportunity to provide whatever oral comments they want to today regarding anything proposed in this rulemaking to date. And in particular, I want to give folks the opportunity to provide oral comments regarding the last round of responsive comments that came in just a little over a week ago. So with that, so I'll tell you that's number one. Number two, I'm going to have a few further clarifying questions just to help me understand primarily the background of customer-owned service lines or customer-owned yard lines as they've been, as I've proposed to refer to them in my proposed amendments. But first, let me ask if anybody has any further comments that they want to make regarding anything in this proceeding. And I see that Mr. Stoffel is turned on his video. So why don't you go ahead, Mr. Stoffel, and welcome.
Thank you. Good morning, Your Honor. Nick Stoffel for Atmos Energy Corporation. So appreciate the opportunity to kind of close the loop on the issues raised in Atmos's additional comments that received responses from UCA and Public Service Company of Colorado. The first was regarding the incorporation by reference of PHMSA's rules. Certainly appreciate UCA noting that the Colorado Administrative Procedure Act limits the extent to which rules can be incorporated by reference. And so that helped to kind of address some of our questions there. PSCO raised an interesting issue around PHMSA's most recent revisions to its rules potentially being delayed. So we agree it would be best if it reflected the most current rules, and it sounds like it might be a bit of a chicken and egg issue, depending on the timing of when the rules here are issued and when PHMSA's rules are finalized. But we generally agree that whatever is in effect when you issue your rules is what should be reflected in the commission's rules. The second one that was raised, the second issue in Atmos's additional comments was regarding the location of regulator vents and relief vents. And we agree with PSCO's response to Atmos's comments on those and think that the language does not need to be clarified further if you just continue to adopt the language from the statute as you proposed. So wanted to close the loop on those issues. Happy to answer questions regarding the history of coils. Generally, we know that issue and defining them as coils originated before it became an issue that Atmos has been dealing with recently. But as we indicated, for example, Atmos's quality of service plan does refer to them as coils, as do the GIP rules, the gas infrastructure planning rules. So that is kind of a nomenclature parties are used to dealing with at the commission.
Understood. Okay, thank you very much, Mr. Stoffel. Appreciate that. Anybody else have any comments they want to make regarding anything in this proceeding? I'm not seeing anybody pop up. So I'm going to move on, but I'll give everybody another opportunity at the end to provide further comments. So basically, what I want to do regarding coils is just understand the history a little bit more. So basically, there were dates specified in the most recent legislation that's driving this rulemaking. And in particular, there was a period of time specified, from August 14th, 1995 to March 1st, 2024. We're required to, among other things, create a rule that will allow customers to understand who has responsibility for what during that period with respect to customer-owned service lines or customer-owned yard lines. So what I want to first try to understand, make sure I understand a little bit better, is during that period, basically pre March 1st, 2024, going back to August 14th, 1995, who had responsibility for the maintenance and repair of, I'll just refer to them as coils, downstream from the outlet of the meter for each of the utilities? Was it determined by tariff, or has the customer always, for each utility, been responsible during that time period for the maintenance and repair of those lines downstream from the outlet of the meter? So I'd appreciate each of the utilities that are participating giving me that information to the extent you know. And Mr. I can't remember, is it Akins or Atkins? You've raised your hand, so why don't you go ahead?
Hi there. Yes, it's Mr. Akins. Thank you, Your Honor. Thanks for having us on today. To answer your question, Public Service has defined in its tariff agreement that the customer is responsible historically for their assets, the customer piping downstream of our meter. So that has been the practice in place for our history here, again, PSCO.
Okay. So that means, Mr. Akins, that the way the rules are currently defined would not, represent a change for Public Service.
Yeah, that's correct. It would not be a change for us.
Okay. All right. Thank you for that. And I see Mr. Stoffel coming online. Go ahead, Mr. Stoffel.
Yep, my understanding is the same is true for Atmos Energy, that customers have always been responsible for the facilities located beyond the meter. And so then with this legislation, we're kind of just defining a subset of that responsibility that has some additional notification potentially attached to it. But that has been the relationship and the responsibility for facilities located beyond the meter, whether they've been coils or long service lines that we've been discussing, or just little short runs from the side of a building into the house.
Okay. And so I'm assuming, I mean, the analog to that, and people can correct me if I'm wrong, but my assumption is that that means that the utility's been responsible for historically during this time period for the meter and everything upstream from the meter.
That's correct.
So if I'm wrong about that with respect to anybody else, just let me know. But so can anybody else? I see Mr. Kosian is first with his hand up. So why don't you go ahead, Mr. Kosian?
Good morning, Your Honor. The same is true for Black Hills Colorado Gas. I would like to look at previous tariffs. We had an acquisition in 2016, and I'm not certain if there was different language in the tariffs for the acquired entity, but my understanding is the same is accurate. Downstream of the meter was the responsibility of the customer.
Okay, thank you. And I see Mr. DiDomenico has popped up, so why don't you go ahead and welcome.
Thank you. Yes, Your Honor. Harry DiDomenico, Colorado Natural Gas, and that is our understanding as well. Downstream of the meter would be customer responsibility, and we don't know of any change in that regard.
Okay, so for at least some period of time prior to March 1st, 2024. I mean, basically you're saying historically, Mr. DiDomenico, that's okay. All right, I got it. Thank you. All right, well, I think that probably covers all the utilities that are here today. So give me just a moment. I have to take care of something. I'm going to mute myself and turn off my video, but I'll be back within a minute. All right, so I'm back. So let me ask this. I mean, based on written comments and the last remote public comment hearing, the movement towards defining customer-owned yard lines to require basically the burial requirement. In other words, some portion beyond the meter being buried is motivated by the desire to basically limit the notification requirement that was in the most recent statutes and that we're implementing in rules here. And specifically the requirement that utility, the operator must notify the customer about who has responsibility for repairs and maintenance of customer-owned service or yard lines within 90 days of installation and or 90 days of an ownership change. So, I mean, do I understand this correctly? I just want to make sure that I have the correct understanding. In other words, the concern is that the notification requirement could encompass a significant number of customers if customer-owned yard lines are not limited to only those that some portion of which are buried beyond the outlet of the meter. So do I understand that correctly?
That's consistent with my understanding.
Okay. And Mr. Akins popped up as well. Go ahead, Mr. Akins.
Yeah, I would say that's consistent with our understanding as well. I would like to say customer-owned yard lines are intended to talk about the situation where that customer piping is below ground, is buried. So I think there's a different risk profile to that piping, hence why, in terms of 192.16 and some of these other conversations around coils, it's just where we're specifically talking about the customer piping of concern. So I just want to point out not just the notification piece, but I think it's important for the definition that we fully capture what truly is a customer-owned yard line. And that's, consistent with the definitions that Public Service has proposed and also as you have proposed it as well.
Understood. So, I mean, what you're basically saying, I think, is there's a risk component to it, which is that the buried customer-owned yard lines are the ones of highest risk potentially in any event. And that's what the notification requirement should be focused on. Do I basically understand that?
That's
All right.
correct. Thank you.
And so, based on the statute, the notification requirement only applies to such, customer-owned yard lines that are installed on or after March 1st, 2024. Do I have that right? I'm pretty sure I do. I just want to make sure.
Yeah, that's correct from our understanding.
So, and since you're still here, Mr. Akins, let me just ask you this again. I'm just trying to understand the record and the justification for this. And I'm going to turn to what the statute actually says in a moment. But I think what I heard, particularly in the last remote public comment hearing, was, we're limiting what customer-owned yard lines are by including the burial requirement. That's, as we just kind of established, motivated by the need to focus things on the highest risk customer-owned yard lines, which are those that are buried. It's also motivated by the desire of the utilities to limit how many customers they have to provide notification to. In other words, there was a concern, I believe, stated that if the burial requirement is not included, that the universe of customers who are required to receive the notice, the notification, could get to be pretty big and thus pretty expensive. So am I understanding that correctly?
Yes, you are.
Okay. So does anybody, so of course the limitation on the notification is it starts on installations from March 1st, 2024 onward. So I'm just trying to understand, you know, the magnitude of the universe of customers who could require this notification. And I know we're crystal balling this to a certain extent, because, you know, March 1st wasn't too long ago. So it's going into the future. That's what we're looking at. For example, does anybody know by each utility how many new customer-owned yard lines have been installed over the last, you know, each year over the last 5 years, something like that? Are a lot of customer-owned yard lines being have they been installed over the last 5 years? Go ahead, Mr. Stoffel.
So for Atmos Energy, as part of the QSP, involves identifying customer-owned yard lines on the company system. So at this point, they're still estimating how many are out there, but the current practice is to not have customer-owned lines be installed and to locate the meter close to the premises and to have the utility own the service to avoid these kind of issues. So I'm not sure how many have been installed each year in the last few years, but I know that the current practice is to avoid installing them at all.
So, and I guess without the burial requirement, essentially, I mean, what the concern is that every new meter installed will have, it's going to have piping downstream of the outlet of the meter.
Exactly.
And also before it enters the structure that, you know, it's adjacent to. So I guess that's what I am looking at is, you know, how many new meter installations have there been each year over the last 5 years, if anybody knows by utility? Because what I hear you saying is, if you take out the burial requirement, we're going to have to provide notification to everybody who's had a new meter installed going forward from March 1st, 2024.
Well, and not just that initial notification, but also the notification requirements if they become aware of a change in ownership, right? So you've got kind of some ongoing responsibility there too. And yeah, I don't know for Atmos exactly how many new services and meters have been installed per year. It's something we could certainly provide that in supplemental comments if you'd like, but you're getting at the core issue, which is trying to tease out, okay, some subset of new service lines that doesn't capture everything. And that's where the burial aspect at least then would distinguish what is more like a service line, a utility-owned service line that runs underground from the customer-owned pipe that is just required to exist beyond the meter in some regard to deliver gas to its ultimate consumption point.
Understood. Okay. Go ahead, Mr. Kosian.
So my understanding is Black Hills similarly does not use coils or does not install meters away from the premise, from the structure anymore. But in terms of meters that are connected or attached to the structure, over the last 5 years, I'd say we're looking at around 3,000 to 5,000 per year.
Okay. All right. All right, and Mr. Akins, why don't you go ahead?
Yeah, we'd be in a similar position where if we need to provide the numbers for the last 5 years or last year. We have to take a little bit more time and provide that at a later point. But I will say, similar to Atmos, we highly discourage in our company practices to no longer install any coils on our system moving forward. So I've been making a lot of effort to reduce that and working with our customers situations that's been requested.
Okay. Thank you for that. Mr. Davidson. Welcome, by the way.
Thank you, Your Honor. Mark Davidson, appearing on behalf of Colorado Natural Gas. And as stated by Atmos, Mr. Koshin and Public Service Company, CNG is doing everything it can, I guess I'd say, to avoid installing customer-owned yard lines anywhere on its system at this time. And to the extent possible, trying to remove or relocate, I should say, any facilities that are capable of being relocated and avoiding having a continued customer-owned yard line in place. So for all the reasons that have been stated by others, we're working with customers to avoid installing any more of those types of facilities.
Understood. Thank you, Mr. Davidson. And any thoughts about number of meter installations over the last...
Your Honor, I don't, but like the others, we could certainly provide supplemental comments with any evaluation within the time frame that you've identified that you're interested in of additional meters that have been established.
Okay. All right. Thank you. And to any of the remaining utilities, let me just move on. But if you have any thoughts about the question I just posed, I would appreciate hearing it. So what I'm really looking for is, I've gone back and looked at the two pieces of legislation that have led to this rulemaking. And what I'm trying to understand is what statutory basis I have for basically limiting customer-owned yard lines or service lines. We'll just keep calling them customer-owned yard lines, but limiting them to those that have some portion that's buried beyond the outlet of the meter. And again, for installations that have happened and will continue to happen after March 1st, 2024. So that's what I'm trying to understand. Obviously, the commission needs to implement this legislation as written. And so I'm looking for a basis in this legislation for drawing this distinction, because I'm not sure it was drawn explicitly, at least, in the legislation itself. So if I have not been clear about what I'm looking for, I'm happy to try to provide further clarification. And I understand, the arguments that have been made and the legal authority that's already been submitted regarding the authority of the commission in rulemakings like this in implementing legislation and what the scope of our authority is. What I'm looking for is argument that basically establishes that what I've proposed is not going too far beyond what the General Assembly and Governor Polis intended in passing this legislation. So I'm not seeing anybody pop up. I mean, does anybody, let me just ask this. Is this a valid question, or do you think I'm just missing the boat? I see Mr. Dixon popped up, so
No one
thank
seems to
you,
be
Mr.
speaking.
Dixon.
No one seems to be speaking. My name's Tom Dixon. I appear on behalf of the Utility Consumer Advocate, and yes, it's a valid question. I mean, you're absolutely correct. Can you in some way limit a statutory definition?
Yeah. And I think it's correct to say, Mr. Dixon, that the UCA is okay with that limitation. I think that's what have you expressed that in your written comments? I believe you have.
Yes, we did.
And so
I think
why?
it's an interpretation of the statute as opposed to limiting it.
Okay.
And I think it's grounded in what's in the, as Mr. Akins referred to, the customer notification requirements in the Code of Federal Regulations, Section 192.16, talks about buried piping. And I know we've already discussed before piping versus service lines versus yard lines. The point is, I think it's clear that that's the intent for customer notification. I think the fact that the statute relies heavily on the Code of Federal Regulations by incorporating parts of it by reference clearly indicates that they're aware of that statute or should be believed to have been aware, and therefore it's an appropriate interpretation, looking at how the Code of Federal Regulations interpret customer notification requirements.
Okay. And I'll stick with you, Mr. Dixon, but this is posed to everybody else as well. I mean, is anybody aware of during this legislative process that led to these two pieces of legislation, whether it was ever proposed to limit what ended up being called in the legislation customer-owned service lines to what I'm proposing here, which is, some portion of it being buried downstream from the outlet of the meter. And in particular regarding the notification requirement. Is anybody aware that during the legislative process that was ever proposed? So I'll just throw that out there.
Your Honor, I would just say I don't know that to be the case, but we can surely check the legislative history. I believe that there are recordings of the committee hearings and the like, if it's really something that we want to search. I have certainly searched that type of material before. But I don't have any personal knowledge. I wasn't involved in the legislation process on this statute.
Okay. All right. Anybody else? Not seeing anybody jump in. So, I mean, you've all figured this out, and I've already basically explicitly stated it. I just want to make sure that what I propose is not going too far based on the legislation that I'm reading and that led to this rulemaking. So, Mr. Stoffel, I see that you popped up. If you'd like to go ahead, please do.
Yeah, I mean, there's some history in Colorado around concern around these customer-owned yard lines that really are trying to address service lines that run from a meter that's not located next to the premises, and likely trying to address some customer confusion around responsibility for that, because there could be an assumption that if it's buried, it's utility property and not customer property. So I think that was that was a known issue when this legislation was passed. As to your question about kind of specific authority to target buried yard lines, as we've discussed, we're kind of trying to define a subset of responsibility within this overarching set of responsibility that already puts that on customers, that they're responsible for anything beyond the meter. But I would flag in 42-115-1.5C, it says the commission's rules pursuant to this subsection must include specific circumstances for when a customer may be responsible. And perhaps that gives you some statutory leverage to hang on to this additional requirement for something that's buried, as opposed to the ordinary customer-owned pipe beyond the meter that's not buried. So it might need some more definitions to kind of tease that difference out, that you have a general rule that customers are responsible for everything beyond the meter, and then a specific rule for buried pipeline where these notification requirements attach. But at least there is some statutory language calling for specific circumstances that you could rely on.
So following up on the point that you just made, Mr. Stoffel, I mean, one thing that could be done potentially is to take the burial requirement out of the definition of customer-owned yard line and put that in the notification portion of the rules. To basically say, customer-owned yard lines doesn't have a burial requirement, and it clearly says that, basically irrespective of whether it's buried, customers, you're responsible for repairs and maintenance for anything beyond the outlet of the meter. But then moving to the notification requirement, that rule, basically say utilities, you only have responsibility for notification for customer-owned yard lines that are some portion of which is buried.
I think conceptually that moves the right direction. When I was thinking about it, while I was sitting here in silence, staring at the statute, the other option would be a definition of customer-owned piping, which is everything beyond the meter, and then customer-owned yard line, which is customer-owned piping that is buried, right? And so I think there is value in that phrase customer-owned yard line, indicating that it's something more than the normal customer-owned piping that they're responsible for. And so perhaps targeting the definition of customer-owned yard line to have the component that's underground, at least in part, but that's a subset of a new concept of customer-owned piping might be the way to kind of tease out that specific instance where the notification requirements would attach.
Got it. So let me just add, and Mr. Dixon, if okay, but let me just add, I mean, I think it will be uncontroversial for me to say that, frankly, there would be benefit to essentially notifying all customers that, you as a customer are responsible for repairs and maintenance of all piping, downstream from the outlet of the meter. In other words, I suspect that there's a fairly large universe of customers out there for whom, that would be news, that they would not have, necessarily known that before getting notification of that. So, for example, I could imagine that there are a fairly large number of people that, even if they have their meter adjacent to the structure that's being served, there's piping going along the outside of the structure before it goes inside the structure. I think there's a fairly large number of people, customers out there who would not know necessarily that the piping on the exterior of their structure before it goes into the structure is their responsibility. So just, theoretically anyway, I think there would be value to not having a burial requirement for the notification. On the other hand, what you're all saying, and I think why the UCA supports this, is that that over time in particular could become an onerous requirement and an expensive requirement to provide notification to all customers, either upon installation of a new meter or change of ownership when the utilities know of the change of ownership, to provide that notification if there's not a restriction, based on whether the customer-owned yard line has some portion that's buried.
Yeah, I'd say I think that's right. I mean, you have as a threshold point, when customers take service, they're informed that their service is governed by the utilities tariff, which includes their responsibility for maintaining this equipment. And so you've already got that kind of baseline that they're held to be on notice of the terms that they're taking service under. And then I think to the point you were just making, if it were a simple notification requirement, I don't think you'd be hearing the same level of concern, but it's a notification requirement with the expectation to pursue signatures, with record keeping attached to it, with additional notification on change of ownership. And so it's much more than just saying you're now taking gas service, you're subject to these tariffs, and under these tariffs, you're responsible for any facilities beyond the meter. It's really then looking at the additional obligations and requirements that attach if you're subject to this statute for this specific yard line, as opposed to just customers' facilities generally.
Right. Right. And so, I mean, the focus has been, what I've been hearing from all of you is, we basically need to define the subset that there's going to be a notification requirement regarding. And again, I think Mr. Dixon can speak for himself and for the UCA, but reading between the lines, at least, maybe he stated this explicitly. I mean, I think that's why the UCA is supporting the latest round of amendments, including, having the burial requirement for imposing the obligation on the utilities that's required by the statute to provide notification. It's basically to try to focus on the highest risk customer-owned yard lines, those that are buried, and limit the notification to those to try to keep this within a reasonable bounds, cost-wise in particular.
I think that's right. And, the statute uses customer-owned service lines. So I think it's intending to target something that's more like a service line insofar as it's underground and running to the property, as opposed to just any customer-owned pipe beyond the meter. So I think that's the other component of the legislation, that it didn't just target customer-owned piping generally, it did target customer-owned service lines, which typically run underground.
Okay, and Mr. Akins has had his hand up for a while. So Mr. Akins, why don't you go ahead?
Yeah, thank you. Hold on one second. Okay, sorry about that. Having some audio difficulties. Can you hear me?
I can, yes. Thank you. Can you hear me?
Okay, yeah, sorry about that. I just wanted to elaborate on something you had hit on earlier, because I think between you and Nick, you're getting in the direction that we support. But the Code of Federal Regulations 192, again, .16, is hitting on some of those points that I think you were trying to look at, whether or not all customers should be notified. And currently in that requirement, the operator is required within 90 days after customer first receives gas to notify them of their customer responsibilities. And then it goes through a list of items that they're responsible for in a very similar way: operations and maintenance and repair. Maintenance and repair. And so I just wanted to point out that the minimum federal guidelines do hit on some of this. I think, as Nick elaborated on, where the concern is and where we need to scope this is because there's additional requirements in the statutory language and then here in the rulemaking, particularly around that customer signature and monitoring whether ownership is changing and all those additional requirements. So I think that's, again, where we're trying to make sure it's adequately scoped and we're including the right criteria for when that notification needs to happen.
And by adequately scoped, I mean, what do you mean, Mr. Akins?
The buried portion. Yeah, buried portion.
And is it public services concern? Like I've been saying that it needs to be properly scoped for, at least in part, cost reasons.
Yeah, again, cost reasons. And I think as Nick elaborated to, the service component or the buried component is kind of where, again, we consider that risk to be. That's, where PHMSA was at when they implemented their rulemaking back in 1995, was to help communicate those risks, those concerns to the customers, and also the responsibilities in case there was any confusion with the customers and what they need to own and maintain. So again, yes, I do think, we want to make sure the notifications are going out to the right people and that we're triggering the correct requirements in that situation. And again, I think in terms of that buried portion, we do think that's where it's important to have that in the COIL definition and subsequently all the additional requirements that follow.
Okay. And let me ask you this, Mr. Akins, as well. I mean, you referenced 192.116. You've done it a couple times. And what you just said had to do with the 90-day notification under that CFR. Does that 90-day requirement, does that apply only to buried piping, or is it did not have that restriction?
It doesn't, but the communication is in regards to the customer's buried piping and maintenance of that.
Okay.
So I think PHMSA in its preamble was clear that they wanted to make sure while the notification, was going out, the communication was focused on the buried portion and who's responsible for maintenance of that.
So, I mean, how does public service handle that under 192.16? Is public service providing notification to everybody who gets a new meter, but focusing primarily on the buried portion in the notification? I mean, that I'm just trying to understand. I mean, how is public service handling that?
Right. So we include as part of our new mover kit, any new customer account will receive a packet of information, and part of that information includes this notification process to let them know who is responsible for maintenance, or that the customer is responsible for maintenance. I think here, when it comes to this language, the difference is there's follow-up requirements that are now part of this rulemaking for signature for, following that customer premise if there's an ownership change. And so while we are doing that 90-day notification, I think where this is different is that there's a lot of follow-up responsibilities that are now tied to it. So again, if you were to exclude buried, we would be, providing not only just that initial notification, but subsequent notifications continuously as those properties are changing hands. And then again, along with the requirements to use best efforts, obtain signatures and the like. So that's again where we're seeing that this is, still an expansion of that, and would then require a lot more additional effort, particularly if you're not scoping out just, the buried portion, but including all customer piping.
Okay, I understand. So let me just kind of reiterate my concern, which is I want to make sure that I'm not going beyond this legislation, and I'm not imposing restrictions that the General Assembly and Governor Polis didn't intend. So, I mean, a few of you have given me in previous comments and here today, thoughts about what the statutory basis would be for imposing this, burial requirement and limiting coils. And, I understand and appreciate that. I mean, what I would not like the commission to hear later is that, that restriction, for example, was proposed in the legislative process and rejected by the General Assembly in writing these statutes. Mr. Dixon was the only one who piped up, but he doesn't have any personal knowledge of the legislative process since he did not participate in it. So, I mean, I understand everything that's been said here today. And I'm basically done with what I wanted to cover. So let me just, before I ask for any further comments about anything relevant to this rulemaking, let me just throw out an idea for going forward. Frankly, at the outset of this continued public comment, remote public comment hearing today, my plan was and still is to just adjourn the hearing at the end, which will trigger my clock to get the recommended decision out and just go forward based on the record that I currently have. There are other possibilities. One is I could adjourn and set deadlines for further written comments, and that would be pretty quick because I need to get going on the recommended decision once I adjourn. And then you could, anybody who wanted to could respond to, what I've been asking questions about today in written comments that I would take into account, obviously, before I finish my recommended decision. Another option, which I was not planning on doing and am not planning on doing, is to, basically schedule another remote public comment hearing together with perhaps more written comments in advance of the continued remote public comment hearing. So in my mind, that's kind of the universe of options. At the end, after I get through the next question, I'll see if there's any preference for or consensus about path moving forward. But before I do that, let me just ask whether are there any other comments that anybody wants to make regarding anything that's relevant to this rulemaking proceeding? Go ahead, Mr. Akins.
Yeah, hi there. Maybe two pieces I wanted to add. First, was able to look up some numbers quickly here, and just ballpark for a number of new meters that we install in PSCO or Colorado territory. There's about 12 to 16,000 new meters every year. So just wanted to give you some context since I know earlier you were asking about that information. And then also just to help understand when we talk about the notification process, kind of that scope that we're talking about there as well. And then the second piece, just in terms of the overall rulemaking, we did just want to point out from our end that PHMSA did issue that stay of enforcement back on June 20th. So we can include an updated link at a later point, but that is in effect right now. And PHMSA did grant a stay of enforcement and discretion up until January 1st of 2025 on that new rulemaking that was issued back in late April of this year. So just wanted to follow up and make sure that was clear for the record.
It is, and I appreciate that. Okay, anybody else want to make any comments? All right. So let me ask, I guess perhaps I think my preference is to adjourn the hearing, but give you all the opportunity to submit further written comments regarding, the question I've posed about essentially whether including the burial requirement for coils, which applies to the notification requirement for all of you, whether that's going too far in light of the legislation passed that has triggered this rulemaking. I'd be happy to give you, another opportunity to submit any written comments. I suspect that there's not really anything new that you would provide, but it would give you all the opportunity to provide further comments. It would be pretty quick. So that's where I'm headed. But if anybody thinks that continuing this remote public comment hearing is the better alternative, I'm willing to listen. And I tell you what, it's 12:30 right now. We've been going for about an hour. So why don't we take a short recess, and that'll allow all of you to think about this. And I can look at a calendar as well and see what possibilities there are for either continued hearing or just pretty fast deadlines. So with that, why don't we be in recess until 12:45 p.m. Thank you. All right, Ms. Wiesenthal, are you ready to go?
Yes.
Okay, we're back on the record in the Colorado Public Utilities Commission's proceeding number 24R-0078 GPS. So we took a break to give everybody an opportunity to think about a question that I posed before we took the break, and I'll just open the floor and see if anybody has any views on the future course. Basically, should there be another continued remote public comment hearing, and or should there be further opportunity for written comments? So Mr. Davidson, why don't you go ahead?
Thank you, Your Honor. I think our preference would be a short clock on some supplemental written comments to address the issues that you've raised today, and not have another public hearing. I don't think it's necessary. You've done a good job in making this available a number of times, this proceeding available to a number of times to various parties, and I think that's sufficient for purposes of the record in this rulemaking. And the additional comments may be informative on this last topic that was raised in the latter part of today's hearing. So that would be CNG's preference at this time.
Okay, thank you for that, Mr. Davidson. Anybody else want to weigh in? Mr. Akins, I see you beat Mr. Stoffel to the punch, so why don't you go ahead?
Maybe barely. Yeah, from public services point of view, we're supportive of the proposed rules as written, but there might be some benefit to having some additional comments as suggested. So we're supportive of that, but we don't have much further to add at this time.
Okay, thank you for that, Mr. Akins. Mr. Stoffel, why don't you go ahead?
Atmos Energy agrees with what you've heard from CNG and PSCO. So we'd support an additional round of comments if you'd find that helpful, and don't see a need for an additional public comment hearing.
Okay. Sounds good. Thank you. Anybody else want to weigh in? Go ahead, Mr. Dixon.
With the comments that have been made by the three utilities, that we do not believe we need another public comment hearing. The public actually hasn't been attending these hearings. It's largely the utilities and us. So I would say that is unnecessary. And I think hopefully maybe since we're all on the same page, we can come up with some consensus final comments on this issue.
Sounds good. Okay. Anybody else? I'm not seeing anybody. So you all basically read my mind. So I'm going to adjourn the hearing. I don't see value in continuing it. I am going to set a couple of deadlines for a last round of initial and response comments. Maybe all that you all want to do is just further initial comments. In light of the July 4th holiday next week, I'm going to put the deadline for the next round of initial comments on July 11th, and then responsive comments will be on July 18th. As I'm just going to reiterate what I basically said to all of you, which is, I just want to make sure that what I'm doing is consistent with the statutes that were passed, and that I'm not going too far in limiting them. So help to me in understanding the legal basis for the current version of the proposed rules as I issued them would be helpful. And in particular, information and or statements about whether the restriction to coils is being the restriction being part of coils being buried, whether that was ever raised in the legislative process and rejected, or whatever. I just want to make sure that what I'm proposing is not going too far. So any help you all can provide to me on that would be helpful. So with that, let me thank all of you. This has been a helpful process as always. I and the commission very much appreciate all of the written comments and other input that you have provided, and trying to help us get to the right place with these new rules. With that, and let me just say, I'm going to issue an interim decision. Don't know exactly when it's going to go out, but it's going to memorialize what I've just said, which is that there will be 2 new deadlines: July 11th for initial comments, July 18th for any responsive comments that anybody wants to file. And in your comments, as always, I've tried to give you direction of what I'm looking for, but you can comment on anything relevant to the proceeding. And that goes for all of you and anybody from the public who may be listening, who are not directly participating in this hearing. So with that, let me thank you again and say that we are adjourned.